Welcome to This Explainer. Today, we are diving into a genuinely fascinating legal mystery from the Constitutional Court of South Africa. We're looking at the landmark case of Fredericks versus the MEC for Education and Training Eastern Cape. And it tackles a really big fundamental question. When your workplace rights suddenly become constitutional rights, who actually holds the key to the courtroom? It's just a fantastic look at how legal boundaries are drawn and, crucially, how they are protected.
Here's our roadmap to solving this puzzle today. We'll start with 1. The teacher's dilemma. Move to 2. The high court roadblock. 3. Defining a constitutional matter. 4. CCMA versus high court. 5. The labor court's power. And wrap up with 6. The final verdict. Let's get right into it. Starting with Section 1. The teacher's dilemma.
So our story begins in the Eastern Cape, shortly after South Africa's transition to democracy, with a group of teachers who simply wanted to take voluntary retrenchment. The situation unfolded pretty rapidly. Back in April of 1996, the government offered voluntary severance packages under something called Resolution 3. And those early applications, they were granted. But then fast forward to December, and the government just abruptly started refusing these applications. No consultation, no reasons given. By 1997, this sudden reversal had triggered a massive legal dispute.
And to even apply for this package, these teachers had already slogged through an intense web of bureaucracy. We're talking 4 distinct levels of approval. They had to go from the head of their institution, up to the regional director, over to the director of personnel, and all the way up to the provincial head. Imagine navigating all that red tape, crossing every T and dotting every I, only to smack into a brick wall of unexplained rejections at the very end.
Naturally, because of this completely opaque and sudden shift, the teachers decided to take legal action. But here is the critical pivot. This is where it gets really interesting. They didn't just argue a standard contract dispute based on the wording of Resolution 3. Nope. They argued that their fundamental constitutional rights were violated by the state. Specifically, they claimed a breach of Section 9, the right to equality, because they were being treated so differently from the earlier applicants, and Section 33, the right to administrative justice, because the whole process was just procedurally unfair.
That brings us to Section 2, the High Court roadblock.
Now, armed with these massive constitutional claims, the teachers marched right up to the Eastern Cape High Court seeking justice. But they hit an absolute roadblock. You'd think a high court would jump at the chance to hear a claim about fundamental human rights, right? Well, instead, the judge looked at the case and essentially said, "I don't have the power to hear this," and literally locked the courtroom doors. He dismissed their application without even looking at the actual facts of how they were treated. The disconnect here was just massive. The High Court looked at the case strictly through an employment lens. They categorized Resolution 3 purely as a collective agreement. And under Section 24 of the Labor Relations Act, disputes about collective agreements are supposed to go to a labor mediation board. But the teacher's perspective was totally different. They weren't fighting over the specific payout terms of a severance package. They were arguing that the state, acting as their employer, had violated the Constitution's Bill of Rights. The High Court completely missed that constitutional dimension.
Moving on to Section 3, defining a constitutional matter.
So, to figure out if the High Court was actually right to lock its doors, the Constitutional Court of South Africa had to step in and define exactly what constitutes a constitutional matter. And they clarified that it includes any dispute alleging that conduct is inconsistent with the Constitution. Because the teachers explicitly relied on Sections 9 and 33 of the Constitution to challenge the state's conduct rather than just the contractual fine print, this was definitively 100% a constitutional matter.
And Section 169 of the Constitution is really the key that unlocks the door here. It clearly states that high courts have the power to decide constitutional matters unless Parliament has specifically assigned that matter to another court of a similar status. So basically, high courts have broad power, barring a very, very specific exception.
Which leads us to Section 4, CCMA versus High Court. The lower court judge genuinely believed that the CCMA, which is South Africa's Commission for Conciliation, Mediation, and Arbitration, had the exclusive power to resolve this dispute because of the Labor Relations Act. But wait a second. If Section 169 says you can only take constitutional power away from a high court and give it to a court of similar status, we have to ask the obvious question. Is the CCMA actually a court?
As it turns out, there was a huge flaw in the lower court's logic. A high court is a constitutionally established court of law with the inherent power to determine fundamental rights.
The CCMA is just a statutory commission designed for conciliation and arbitration. It is absolutely not a court of law, let alone a court of similar status to a high court. You just cannot take constitutional power away from a high court and hand it over to a mediation commission.
This entire dynamic is perfectly captured in a powerful quote from Justice O'Regan, who wrote the unanimous judgment for the Constitutional Court. She stated that the CCMA cannot oust the jurisdiction of a high court for the simple reason that the CCMA is not a court of a status similar to a high court. That quote right there is basically a judicial mic drop on the idea that a lower mediation body could strip a high court of its constitutional duty to protect human rights.
Now for Section 5, the labor court's power.
Our investigation isn't quite over because there is another major player in the system, the labor court. Now, unlike the CCMA, the labor court actually is a court of similar status to the high court. So did Parliament assign this case exclusively to them? Well, if we look at Section 157 of the Labor Relations Act, we see a very careful division of power. Yes, the labor court has exclusive jurisdiction over standard labor matters explicitly determined by the Act. But the Act specifically says the labor court has concurrent jurisdiction, meaning shared power with the high court, when it comes to alleged constitutional violations by the state acting as an employer.
Think of it like a sports analogy with umpires. If it's just a standard foul, say a routine dispute over work hours, only the dedicated labor umpire has the whistle. But if a player's fundamental human rights are violated on the court by the state, the rules say that both the high court umpire and the labor court umpire have the jurisdiction to blow the whistle. It is a shared responsibility.
And finally, Section 6, the final verdict. Having gathered the clues and interpreted the statutes, the Constitutional Court delivered a resolution that completely restored access to justice for these teachers. In a unanimous decision, they ruled the High Court was totally wrong to lock its doors. Step 1, the teacher's appeal is upheld. Step 2, the High Court's original order dismissing the case is set aside. And Step 3, the case is referred right back to the High Court so the teachers can finally have a proper trial on the actual merits of their constitutional claims. The procedural roadblock was entirely demolished.
This explainer leaves us with a really critical thought to carry forward. This case wasn't just about teachers in the Eastern Cape. It's about the very hierarchy of our legal system. It proves that administrative bureaucracy and standard labor statutes cannot just override the unbreakable nature of constitutional protection. If your fundamental rights are violated, the highest courts in the land are mandated to keep their doors open to you. It really makes you wonder, in our complex modern workplaces, how well do we truly understand the powerful constitutional safeguards sitting quietly beneath our daily employment contracts?